Hello everybody, it's Rick again. It's June 29, 2017. You need to contact me. The email is rick0327. And we're starting part 2. Now, we need an injury in fact for a support order. Now, all judgments made by the court is a remedy for a redress. What is a redress? A redress is a problem brought to the court, and the court's duty and job is to fix. That's the remedy, right? So, where's the injury in fact caused by you? Now, how are we going to get the court to go along with this? Well, we're going to have to cite that Supreme Court case, right? Then, a subscriber of mine, you know who you are, and in the comment section, remind me, who told me, Rick, take a look at 28 U.S.C. 2072. And what that says is that the Supreme Court sets the rules and procedures for the court. And the court must go along with it. They must protect your substantive rights. They gotta play games with words, right? What's your substantive right? You know what your substantive right is? Life, liberty, and property. And where is your life, liberty, and property protected? Well, it's protected by the guarantees in the Bill of Rights. Okay? Therefore, any procedure in violation of your substantive right must be ignored because it's void. So if we get some clerk playing fucking games, or a court playing games, saying, well, child support rule and procedure, this says we don't have to do that. We don't have to provide you a trial by jury. Bullshit. 28 U.S.C. Section 2072 says you're supposed to. And the Supreme Court says that I have substantive due process. What's substantive due process? It's the due process guaranteed in the Bill of Rights. Okay? So, you got the Supreme Court saying that every case, every petition brought before a court, there must be an injury in fact. The injury in fact, now again, it has to be an injury, a concrete injury. That's the word used by the Supreme Court, by the way. A concrete injury by Judge Scalia. The guy just died last year under mysterious circumstances. And then the concrete injury had to have been caused by you. Okay? So now the court can only redress this based upon two things: evidence in fact and proof that you caused it. That's it. Now, 28 U.S.C. Section 2072, we're going to tell them, the court, that based on 28 U.S.C. Section 272, you're supposed to follow the procedures as set forth in that Supreme Court case. And if you're not, you're violating my substantive due process. Real simple stuff, guys. And that's what I've been working on the last couple of days. All right? So, this is the end of part 2. I hope everybody's paying attention. Okay? So that means when you go to court and you're standing before one of these idiots, remember, we're going to object. Objection. Where is the proof, where is the evidence introduced by the petitioner that I caused an injury in fact? That's it. Objection. Where is the evidence introduced by the petitioner of the injury in fact caused by me? That's it. And if they refuse to answer, you say, objection. Let the record show whoever the person is, whatever their title is refusing to comply with the Supreme Court case. You cite the Supreme Court case, and you take it from there. That way it's on the record. That way, on appeal, okay, or writ of mandamus down the road, it showed that you objected and that you were right. The higher court must go by Supreme Court decisions. They don't have the luxury of being wayward like these kangaroo courts. Okay, these tribunals, that's what they really are. They're tribunals, they're kangaroo courts, and that they're allowed to get away with this stuff because they know that the higher courts are going to correct them. And most of us don't go to that higher court because most of us have an attorney, and the attorney never does it. What does the attorney tell you? Oh, you got to pay child support. That's the way it is. When you ever hear an attorney talking about an injury in fact? Has anybody heard that before? Well, I found it. All right, guys, it's 6:45. Let me shut this video down before I lose you.